before. I have earlier instructed the clerk to Parliament to transmit the LQBTQ plus bill to the President for assent. Ladies and gentlemen, finally, I'm aware of the business the government wants to transact through Parliament. And I'm willing to cooperate and collaborate with government. Despite all that I have said, Ghana first. And all Ghanaians should bear the President, Parliament, the Judiciary, and all our leaders in prayer for the betterment of our people and country. With this, I thank you all for your attention. Assalamu alaikum. Young to wear the hat of an old lady. I don't have that wisdom of the old ladies. Let me also add my voice in welcoming all of you to this afternoon presser, and I'll do all I can to be as brief as possible. Beloved Ghanaians, democracy will work only if we fight for it, says President Barack Obama of the United States. I swore an oath to uphold, preserve, protect, and defend the Constitution of the Republic of Ghana, and that I will do right to all manner of persons in accordance with the Constitution and the laws and conventions of Parliament, without fear or favor, affection, or ill will. I concluded the swearing of the oath with a call on God to help me. I'm very confident and have faith in God to see me through these dark days of Ghana and our young democracy. Ladies and gentlemen, I want to start this presser by disabusing and setting the minds of Ghanaians at ease. There is no constitutional crisis in this country. I repeat, there is no constitutional crisis in this country. The Parliament of Ghana is alive and working. Let nobody mislead, misinform, or disinform you and the country. The democratic system we adopted and enacted, as captured in the Constitution 1992 and fleshed out in various laws, processes, procedures, and practices, is what has been triggered, and it is working. Let us allow it to work. Democracy is about the rule of law. Let the law work. The democratic system we adopted and enacted recognizes that in the course of operationalizing the system, disagreements will occur and challenges and problems will arise. The system has put in place mechanisms, structures and institutions, processes, procedures and rules to follow and apply to resolve the disagreement, convert the challenges into opportunities, and provide solutions to the problems. This is what is being pursued and applied. There is no constitutional crisis in the country. Beloved Ghanaians, I have served Parliament and the people of Ghana continuously for over 32 years as a politician and over 42 years as a public servant. I cherish the role Parliament plays in our democracy, and my mission is to leave Parliament a stronger institution than I met it. Parliament is alive and working. It has not been dissolved, prorogued, prohibited, suspended, or terminated. The plenary sitting and meetings of Parliament were adjourned indefinitely due to lack of quorum to take decisions created by a workout staged by the NPP members who were available as a result of a disagreement. The cause of the disagreement, which led to a disorder, had to be resolved with time and engagement of many more leaders than those in Parliament. The adjournment was done by the lawful authority, the Speaker of Parliament. Let us stop pressing the panic buttons and fear-mongering and allow the system to work. Anger and indecent language rather inflames the situation. There can be no democracy without patience, tolerance, discipline, collaboration, the love for one another, and consensus building. Ladies and gentlemen, one may ask, what led to this disagreement? Following a statement by Honorable Dr. Addo on a matter he considered to be of urgent public importance on the 15th of October 2024, and comments thereof by other members as permitted by the standing orders of Parliament, I communicated the findings of my inquiry into the matter as the Speaker of House on the 17th of October 2024, the contents of which has been construed to be a ruling. The Honorable Alexander Afenyo-Markin disagreed vehemently with the contents of my communication as the Speaker of Parliament and proceeded to advance an earlier action he had commenced in the Supreme Court on the 15th of October 2024 to prevent the Speaker of Parliament from receiving and making any pronouncement on the subject matter of the statement made by Honorable Dr. Addo until the final determination of the matter by the Supreme Court. The rest, we say, is history. Ladies and gentlemen, being a party to the suit in my official capacity, I am mindful of what I say. But it must be said, the suit before the Supreme Court raises not just legal questions, but more importantly, has profound implications for our democratic system of governance. At its core is the very essence of our democracy. While many legal arguments have been advanced in and out of the court, I recognize the fact that connected political and governance implications have not been addressed sufficiently to enrich the national discourse. It is my considered view this should also be vigorously articulated to give a holistic approach to resolving the issue. As one of the protagonists in this matter, and a long-time practitioner, it will be a disservice not to respectfully draw your attention to some of the facts, principles, and ethics of politics and governance, the practice and procedures of Parliament, and what is generally referred to as parliamentary law, to throw light on some aspects of the matter and to clarify the considerations that underpinned my actions. The current brouhaha may be likened to a power play between the arms of government, and has the potential to undermine our democracy and the authority of Parliament. Its outcomes could subvert Ghana's constitutional order and the democratic system. Ghanaians have toiled, sacrificed their lives, and shed blood to establish for decades. Ladies and gentlemen, recent acts of the judiciary and executive, and I see them as interference in the workings of Parliament, pose a direct challenge to the essence, jurisdiction, authority, powers, and functioning of the esteemed institution of Parliament, which is the repository of the sovereign will of the people of Ghana. It is increasingly becoming clear the judiciary and the executive are seemingly colluding to weaken Parliament. The decision of the Ghanaian voters in the 2020 presidential and parliamentary elections is clear and loud to all discerning people. The decision is obviously a preference for a consensual and collaborative governance to a winner-take-all government. The majoritarian system of Parliament, where the minority have a say, but the majority have its way, was rejected by the voters. They rather opted for inclusivity, collaboration, consensus building, leaving nobody behind. The equal representation of the two major parties in Ghana, resulting in the composition of a hung parliament, to the voters is the better way forward for our dear nation. The expectation of the voters is this will lead to the constitution of a parliament where the national interest will prevail as against partisan or parochial interests. This is the context and the peculiar situation I have to preside over as a speaker. I'm the first speaker in the Fourth Republic, in fact, in the history of Ghana, to work with a president who belongs to a different party, to work without a majority party in Parliament, but with an evenly divided Parliament, 137, 137 apiece. That is a hung Parliament. Decision making has therefore not been smooth sailing. As a Speaker of Parliament, I hold the balance in favor of the national interest, but sometimes bend backwards to accede to government requests because government has been given the mandate to govern. It is with this understanding I led the board of the Parliamentary Service and members of Parliament to provide procedural rules of engagement to actualize this goal and to provide for the possible types of government as envisaged in the Constitution. These possibilities include an election of an independent president to form a government, somebody who contests, as we have now, as an independent presidential candidate can be elected by the voters as the president of Ghana. How is he going to work with Parliament to get his or her business, that is government business, approved by Parliament? We have a possibility of a minority government where the voters vote for the president, but he has less members of Parliament. And that is a minority government. How is he going to get the majority members of Parliament to always approve his business for him to govern the nation? We can also have a coalition or a merger of parties government. And the familiar one we know is a majority government. These are possible governments constitutionally guaranteed in Ghana. In the current hung Parliament, the new standing orders of Parliament had to cater for such a government by a number of provisions in the standing orders. We also provided provisions for all the other options of government that I just explained. For instance, a day which we call a decision day has been designated in the new standing orders, where the Speaker, in consultation with the leadership of the House, will set aside to allow members of Parliament who are ministers and deputy ministers the opportunity to be present in Parliament to be counted in support of government position to ensure government business does not suffer for lack of government members of Parliament in Parliament.